Hi there, Ariel Overstreet Adkins here. I'm an attorney and founder of Bluebird Law in Billings, Montana, and I'm here today to address a frequently asked question. That question is, what is a will? A will is a document that is only going to come into play upon your death. And in your will, you can designate, number one, who you want to get your stuff, and number two, who you want to administer your estate. A will is also a great place for you to make a nomination of someone that you would want to act as a conservator or guardian of your minor children should you pass away before they turn 18. A couple definitions, someone named in a will to receive assets is called an heir or a beneficiary. And the person who's put in charge of making sure that that happens is called the personal representative. It's important for you to note that not all of your stuff is going to pass according to the terms of your will. If you have anything in joint ownership with rights of survivorship, or where you've already designated a pay on death or transfer on death beneficiary, think things like life insurance, retirement, investment accounts, bank accounts, things like that. Those assets are going to pass directly to the survivor or to the designated beneficiary upon your death, regardless of what your will says. These types of assets that do not pass according to the terms of your will are also then pass outside of the probate process. So a probate is where the person designated as personal representative in a will or any other interested person, if there is no will, files an application with the court to have the will or the estate admitted to probate. This process officially designates the personal representative and gives them the authority to act on behalf of the decedent's estate. The personal representative then is responsible for gathering assets, paying any creditors that might be owed money, and then ultimately distributing those assets to the heirs or beneficiaries. Wills are a foundational part of any estate plan, but they are not the end-all be-all. A will cannot and does not cover every estate planning scenario. So for example, a will does not cover the situation where you might be incapacitated, so you're still alive, but you can't act on your own behalf. There are other documents that come into play in that type of situation. So there are other important documents that are essential to a good plan other than a will. But that's a will in a nutshell. I invite you to schedule a free 15-minute consultation call with me to discuss your situation and how we might work together to achieve your goals. I hope you have a great rest of your day, and we'll see you next time.